In our 16 webinar series, Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law at the Catholic University of America. I'm the Catholic University Director of the American Law Program and the LL.M program, in which Catholic University has cooperated with Jagiellonian University in Kraków, Poland for many years. And I will be your moderator. Cristina D'Amelio Lopez, Director of Advancement of the Law School's Development and Alumni Relations Office, will bring greetings from the Columbus School of Law of the Catholic University of America.
Hi, everyone. Thanks so much, Professor Wortham. It's quite an honor to be invited here with all of you today. So please allow me to thank Professor Wortham once again for her creativity and leadership in the design and the facilitation of this program series. It's been really successful to engage all the cohorts across the globe, amplifying the Jagiellonian University and Catholic law relationship. Professor Wortham is a passionate scholar who continues to keep the unprecedented relationship between the Columbus Law School and Jagiellonian University grounded and active and alive. As we remember the founder emeritus, Professor Rhett Ludwickowski. I would also like to underscore how much we value the 30-year collaboration with Jagiellonian University. So welcome. We are joined here today by close to 250 registrants. That's amazing. Together, we've been able to continually grow this community virtually, thanks to the active continuation of the dialogue that you've participated in and have begun to share about these legal global issues. Thank you for being here with us again. We value your participation, and we look forward to seeing you in the continuation of this webinar series. So please share the next schedule of series with friends and colleagues. Professor.
Thank you. Wojciech Jarosinski, the coordinator of the American Law School for Jagiellonian University, will welcome on behalf of Jagiellonian.
Thank you very much, Professor Wortham, for this invitation and this short introduction. It's also a great pleasure for us, the Jagiellonian University, that this series of webinars is possible to take place. So we try to benefit at least somehow from the pandemic and from much more often realized possibilities that we can meet online, which won't be possible in another way, and which maybe generally wouldn't be possible at this time of the year, even without the pandemics. It's a great pleasure that we all, as friends, graduates, participants, future participants, namely everyone who's interested in American law and global law, and we can all meet here and participate in a series of webinars. It's a great pleasure that the interest of so many people has been shown in contemporary challenges and varied initiatives coordinated by the Catholic University of America and the Jagiellonian universities. We are very happy that so many initiatives have been developed throughout many years of cooperation and longer than the lifetime of quite many participants. In these current difficulties, it's very difficult to meet in any other way, but we are very happy that a new initiative has been developed, and in the absence of traditional Insight meetings, we are here all together. At the same time, we do hope that sooner or later we'll meet in person during our programs or alumni events.
Thank you. So we're delighted to have so many people on both sides of the Atlantic. I want to remind you that we have 2 more law and technology webinars in December. December 2nd on data privacy and December 9th on intellectual property issues in artificial intelligence. As I'll mention in his introduction, Mr. Nagle is a graduate, has a certificate from our what used to be called our Communications Law Institute, that's now called our Law and Technology Institute. Catholic University has a long-standing, outstanding program in communications that's now branched as the field has changed into law and technology. And Jagiellonian also has a very strong program in intellectual property. So this is a place in which we have also much mutual interest. So please encourage fellow classmates, friends, and colleagues who might be interested. I think Gaspar Coate's going to put up for us in the URL for the series again to remind you. At the beginning of December, we'll be posting the information and advertising the January webinars. And we expect that before Christmas, you should have the registration links for the 6 webinars in the winter series. That's January, February, and March. So the webinar series is a team effort that benefits from the strong support of our deans, Stephen Payne at Catholic University, and Dean Wojciech Jarosinski, Dean of the Faculty of Law and Administration at Jagiellonian. It is based on the leadership of the staff of the Foreign Law School Cooperation Center at Jagiellonian, known by its acronym OXPO, and the Catholic University Central and Law School Development and Alumni Offices, who provide so much vital support that makes this all possible. We also rely on our LL.M coordinators, Gaspar, and LL.M graduates, Gaspar Cote and Luke Bartosa. So we'll now turn to today's program with our LL.M graduate, Wojciech Jarosinski, on the cloud, a new legal frontier, with comments by our Catholic University JD alum, Paul Nagle. So Wojciech, you can go ahead and put the screen share up of your slides while I say a few words about how the webinar operates and also introduce you and Paul. I expect most of you've used Zoom or a similar video conference platform before. I already mentioned information in the chat. You'll see a chat button in the tray at the bottom of your screen, or depending on your device, it might be on top or on the side. When you click on chat, you can see the things that others have typed in chat, and there's a bubble at the bottom where you can type your questions that you would like directed to the speakers. In the Zoom version we're using today, you can also see a participants button. When you click on that, you can see the names of who is signed on, as well as if you go to gallery view, you could also look at the screen names of the participants. You can use the participants list and the screens to somewhat replicate a little bit of the networking that you could do in a live event. So if you see a classmate or colleague that you would like to send a message to, you can switch from everyone to their name and send a private chat to them. Unfortunately, this software does not recognize some Polish characters, so we apologize if your name shows up with some question marks. When you register, try just to use the regular Anglo character instead of the Polish one, and that will avoid the problem. So Mr. Jarosinski is going to speak for about 20 minutes. He'll be followed by a short comment by Mr. Nagle, who will also lead off the question and answer period. So as I mentioned, please type your questions in chat as you think of them, and I will pose the questions in chat to our speakers. This session is being recorded, and the 60-minute webinar will be posted on CUA's YouTube channel within a few days. The series website also links to those recordings, so you can find them there. At the end of 60 minutes, I'm going to close the formal webinar and the recording will cease, but Mr. Jarosinski and Mr. Nagle graciously have agreed to stay on for up to another half hour so we can take more questions. So I encourage all of you who would like to stay on for that question and discussion period. So in the chat, you will now see links to bios for Mr. Jarosinski and Mr. Nagle. And so you can check, you can click on those if you would like more information. But I'm gonna just read a few highlights. So Wojciech Jarosinski is a partner at the Maruta law firm in Warsaw, Poland, where he heads the dispute resolution group. He has led or supervised more than 200 technology litigations with a combined value of more than $2 billion and advised on execution of technology projects of the same magnitude. The Lawyer magazine in the United Kingdom has rated the Maruta firm as the best specialist law firm in Europe in 2018, the best Polish law firm in 2019, and the best law firm in Central Europe in 2019. The most prestigious Polish legal ranking, Rzeczpospolita Daily, named Mr. Jarosinski the top dispute resolution lawyer in Poland in both 2018 and 2019, and ranked the practice group he leads in the top 5 for dispute resolution in 2017, 2018, and 2019. National Jurist, which is a US magazine that's available to US law students and lawyers, featured him in Who's Who of Foreign Attorneys in the fall of 2019. Mr. Jarosinski received his magister degree from Jagiellonian University and is a member of the Advocates Bar. In addition to law practice, he created and manages Vertical Shot Expeditions, which offers photography workshops in remote locations from the Arctic to the Antarctic. Paul Nagle is Director of the Intergovernmental Affairs at the International Government Affairs, at the Alibaba Group. He received a JD from Catholic University Law School in 1999 with a certificate from CUA's well-known Communications Law Institute, now called the Law and Technology Institute. Mr. Nagle's more than 20-year career parallels the evolution of technology in communication, e-commerce, data storage, and the many other ways that web-based applications affect our daily lives. His work has reached issues in trade, foreign investment, data privacy, intellectual property, telecommunications, cybersecurity, and much more. His career spans both chambers of the US Congress, the executive branch, the corporate world, and private law practice. He has served as chief counsel of the US House of Representatives Subcommittee on Digital Commerce and Consumer Protection, chief counsel to the US Senate Committee on Science and Transportation, as an attorney advisor at the Federal Communications Commission, and in private law practice and a DC government relations firm. As with all our speakers and commenters, employment is given for identification only, and Mr. Nagle speaks on his own behalf. We now turn to Mr. Jarosinski. Please remember to type your questions in the chat, and his remarks will be followed by Mr. Nagle's comment and leading off with the questions. Thank you.
Thank you, Leah, for your introduction. And I'm really grateful for the opportunity to give this webinar, to offer this webinar being the graduate of both Jagiellonian University and Catholic University of America. That's a true pleasure and honor. Now, to the topic of today's webinar, Cloud, a new legal frontier. I would like to actually start my story, this webinar, in the distant past, at the beginning of 21st century, when the cloud computing was still a young concept. Microsoft, Google, and Amazon were just starting to play with the idea that the user does not need a physical server to be able to run its computer programs. You may ask how computing was conducted then. The traditional approach was, let's say, skill-based. And what does it mean? Let's work with an example of a e-commerce sports apparels internet shop. The shop in our example is run by Tom. Tom inherited a stationery shop in, for example, Superior, Wisconsin, in late 90s. And then he set up a website, which was basically his business card at this time. Later, Tom added a list of items available in his shop to that website and his office email. Customers started to send emails and purchase goods without visiting actually the stationery shop. And up to that moment, Tom undertook all actions in the digital world from his office computer, a regular PC machine. But Tom wants to see his sales grow and be like Amazon. So what if Tom decided to scale up at the beginning of the year 2000? Tom needs to upgrade from his office PC to a professional server. And this is exactly our skill-based computing. Tom can have the server installed in his shop's basement. It is convenient because it does not require additional investment. And on that server, Tom can deploy a professional website, which allows for browsing through apparel available in his store, adding items to the basket, and has this nice web form for purchasing goods from his store. And if Tom's marketing strategy is successful, then sooner or later, Tom would notice that clients become dissatisfied with his shop because their online experience is deteriorating. And why is that happening? The one server in his basement that does not have sufficient capacity to handle all the traffic. In addition, Tom is inclined to add new features to help him sell more and sell faster. Such features put additional load on the server, making its reactions even slower. What solutions? What solutions Tom has had at the beginning of the 21st century? Simply more servers. Actually, if you remember the old joke that for buying IBM, you couldn't be fired, those pictures are the pictures of the well-known mainframe from IBM. And that's what probably Tom could use. And Tom's growing business requires live data on availability of shop supplies, integration with delivery services, integration with customer support, call center. Tom's basement becomes filled with servers to the point that the local electric company simply contacts him to discuss a separate power line because of the huge energy consumption from his basement. At this point of time, Tom has hired dozens of IT specialists who take care of the infrastructure, probably built a power generator to ensure continuity of the services, and co-located his servers to limit the risk of natural disasters. And in mid-2015, Tom realizes that the technology of his steel-based servers prevents his company from any further growth. Therefore, Tom is forced to consider either a substantial investment in changing his infrastructure or migrating all systems to a new set of servers. Does Tom have any alternative? Yes, after the long introduction, we are arriving at the cloud computing. Tom can consider migration to the cloud instead of buying new servers. And what would change? What would change if Tom actually migrates to the cloud? There will be more storage in the basement because he can decommission his servers. Probably a dozen unemployed IT specialists in Superior because he needs less IT specialists, less worries of natural disasters or power outages that can threaten his infrastructure, flexibility in adding or removing computing power, so no more decrease of user experience due to overloaded infrastructure, probably assurance that the technology is constantly updated, and likely less expenditures, and certainly switch from capital to operational expenditures. So what is exactly that Tom can get? He can get a service that provides an on-demand data storage and computing power. Simply speaking, Tom, when buying a cloud, simply buys computer system resources for hire. It's like car versus Uber. Car is the infrastructure which enables a person to get from point A to point B, while Uber is a service that enables a person to achieve the same goal, but without the cost of and trouble of owning a car. Cloud-based computing resources are available through the internet, and the common forms of cloud are public cloud, where the resources basically are available to anyone, usually through paid subscriptions and through the open link to the internet. Those are all the popular solutions like Amazon Web Services, Google Cloud, Microsoft Azure. Those computing resources are available to any user. And the great performance is achieved due to economics of basically shared economy. Sometimes it's possible to request a separation of those services from another users, but that actually depends on your bargaining power. Then there is the private cloud, another model that's basically something like Tom already has. The difference between Tom's servers in the basement and the private cloud is that the infrastructure is usually managed by an outside company, by a professional who specializes in data centers and probably has more similar clouds under their management. And that also allows for a cheaper pricing. Finally, there is the hybrid cloud, which basically is connection between these two. Some of the data you can store on private cloud, and some of the data can go to the public cloud and be easily available through the internet. The cloud service can be offered to Tom in different models. If Tom wants to evaluate solutions from the perspective of how much control he requires over the resources it can access, he can purchase infrastructure as a service, where a user does not manage or control the underlying cloud infrastructure, but has control over the operating system, likely storage and deployed applications, possibly, depending on the service, limited control of selected networking components. For instance, firewalls would be the usual example. Platform as a service, where a user can deploy onto the cloud infrastructure user-created or acquired applications. Basically, the user has control of something that, like you see on your computer, has control over the platform up to the point of operating system, and can install applications on top of that. Finally, the very popular software as a service solution, where the user is just provided an application, and those applications are accessible from various clients' devices through either through different interfaces, such as web browser, fancy name is thin client, or a program interface. There are also other ways of something as a service, depending on how deeply you go with your ability to control the infrastructure that is offered to you. But back to our Tom. He would probably look into the infrastructure as a service or platform as a service, depending on his actual needs, how much control he wants. And this webinar, for example, is possible thanks to Zoom's software as a service solution. We do not need much control in order to execute the webinar. Software as a service is enough for us. We access this service either through the browser, the fancy name thin client, or through an application that was installed on our computers. That's how I actually use the Zoom. And with that introduction, you may ask where actually this new legal frontier is. Tom can actually contract cloud computing resources through old-fashioned contracts. In Poland, such legal relationship would even fall into the category of a already codified service contract. Negotiations of such contract would be extremely limited. That's a publicly available resource, which is highly commoditized. The contract for cloud computing is unlikely to be negotiated unless Tom has a substantial business needs which would attract vendors' attention. However, even though Tom's options for negotiations would be limited to like business metrics, perhaps some priority or performance metrics, just the nature of cloud service, which take the competitive edge from basically uniformity, makes asking for and negotiating customizations unlikely. And but if Tom decides that the cloud is for him, then Tom needs to contract a project to migrate his system and data. Tom may face some legal challenges when attempting to convert the on-premise licenses, those licenses he had on the servers, to cloud licenses. But this is nothing new, right? Tom does not need a new legal vehicle to move to a cloud, at least not from the perspective of private law. Us, the lawyers, we do not need to invent new legal vehicle either to help Tom. We can effectively provide legal services related to the cloud computing on the level of private law by using well-known tools of contract law and IP law. When I discuss this matter with Polish lawyers, I often actually joke that the cloud can successfully be served by legal institutions of the Roman law. The interesting factor, to those of you who are not familiar with Roman law, this is Julius Caesar. The interesting factor of private law's interaction with the clouds is just its vulnerability to forum shopping. Because technology is jurisdictionally diverse, cloud even more so, and business can be located in one jurisdiction, data center where business activities are processed in another or actually multiple, and the end customers can come from all over the world. And because of the jurisdictional diversity, it is easy to end up litigating in an unfavorable jurisdiction. Therefore, wherever possible, I would recommend adding arbitration clauses to cloud contracts. But once that's done, Am I safe as a lawyer? After this webinar, you'll know that actually help clients which want to switch to cloud services by applying the legal tools which you learned at the law school. So is that right? Is there nothing new to learn and this legal frontier does not exist? Of course not. And at this point of my webinar, I'm sure that most of you already realize that in order to assist clients in cloud services, a lawyer must understand technical and business concepts behind these services. And this is just the pleasant half of what I'm about to tell you. The other half is much less so, at least to a private lawyer like myself. And let's get back to Tom and focus on two elements of his newly purchased cloud service. Does the user experience of the systems which Tom is using changed significantly from his perspective? That's unlikely. He still sits at his desk, looks at the screen of his computer and smiles and nicely displayed charts. He has never been to the basement where he used to have servers. That's what happens only in movies when hackers go there. Tom have always been interested only in the functional parts of his systems, which are displayed on his computer screen. Does Tom pay less for the same computing power? Likely yes. Are his customers better served in the online shop? Also likely yes. How is this achieved? Tom likely decided to purchase computing power in one of the public clouds. Such solutions benefit from the economy of the scale. Tom's systems are deployed on an infrastructure, cloud infrastructure, which costs are divided between multiple users. In addition, this infrastructure can be located closer to his customer, and that enables faster response from the website. The provider of cloud service can also select a cheaper location for the data center, including another country. And does this affect how Tom's systems work and operate? No. But systems are dead without data. And data is where the challenge begins. Data can be personal or non-personal on a very basic level. Data can be transferred, can be addressed, it can be processed, but what is data? Data has no common definition. Data has no common qualification as a legal concept. Is data a chattel? Can it be owned? Is data an element of innate rights of a person? What is the public interest justifying a state's interference or access to someone else to private data? Such questions are not resolved in jurisdictions across the world. Even if such questions are resolved, resolutions are far from unity. At the same time, Tom's business model enables customers from Canada, Mexico, the UK, European Union, or Texas to make purchases in his shop. What more, Tom could be inclined perhaps to consider an offer of a cloud service based in Morocco, next to a giant solar power plant which offers competitive prices for energy-hungry computing power. But can a US-based merchant store data of an EU citizen in Morocco, transfer it to the USA and process there? The challenge of answering these questions is not limited to the e-commerce merchants. It's basically everywhere. Imagine a typical situation in which a lawyer like us is the main actor. You visit a client who shows you an interesting document, and instead of copying information contained in that document with a pencil to your notebook, who does that anymore? You just take a photo of the document. And how convenient it is when that photo instantly appears across all other devices you own. And this is achieved through cloud services offered to you by the vendor of your systems. And did you ask yourself a question? How does it affect client attorney privilege or personal data protection regulations when your client's data is synchronized across devices for a foreign located server? When, like in our example, Tom purchased and installed his servers, he had control over where the infrastructure was located. He had some control over the data. With cloud solutions, that control is not exercised through physical means. In other words, a control over physical location of the server. That control can only be exercised through law. However, if you think that a cloud service purchased in the EU from or from an European vendor is automatically in compliance with, for instance, GDPR, you may still be wrong. The cloud provider does not need to know what kind of data you intend to process through its service. It may be personal data, but as well, that may be non-personal data, which does not require the same level of safeguards. For example, data on COTS movement patterns in the Northern Atlantic important to to fishing industry. And the data classification, the risk assessment which follows, and the decision on where and how to store and process certain data is a task which must be completed by the user of a cloud service or an entity which exercises control over the data. Completion of that task is a mix of legal rules and technical knowledge. The user must ask itself, am I processing personal data, or is it just non-personal, some data? Am I regulated by an administrative body like a financial watchdog? Or am I regulated by rules of professional conduct? Once those questions are answered, the user must extract the rules which govern data management from applicable regulations. And such rules are not always written in a direct and unambiguous form. For example, how clients' data can be processed in the cloud. It's not written like that. Sometimes such rules are codified in relation to traditional data storages, like confidentiality of written documents. Those rules still apply to the digital world, just expressed in different terms. And these tasks, they often require assistance of a lawyer. Often these tasks cannot be completed by a user because of complexity of regulations. I must admit, especially at our European end of the Atlantic. In the same time, lawyers' data classification and risk assessment cannot be completed without support of a technical team, which helps to evaluate risks of using systems or cloud solution against classified data. And here is where the new legal frontier truly is. Its borders are marked by cross-jurisdictional legal challenges, mix of private and public law, and necessity to combine legal and technical advice to offer clients a comprehensive legal support. And cloud services are an enormous market, a market which is now destined to grow and to develop because basically the pandemic switched the way we work, learn, and even live. But even before the pandemic, the market wasn't small. My law firm alone advised on investments contracts to build 2 new data centers in Poland. One by Google. This value is confidential. However, Google publicly informs that it plans to spend $3.3 billion on data center presence in Poland. In Europe. The other by Microsoft, where the value is actually public, and Microsoft is investing $1 billion in cloud computing in Poland. And that's a fascinating new area of business, offering lawyers opportunities to flourish in international context and excel in interdisciplinary fields of technology and law. I strongly recommend a venture into this new legal frontier. Thank you.
Thank you so much. And let me now, and this was also an excellent commercial for our webinar on December 2nd, which is on data privacy. So you can hear chapter 2 then. So let me now turn to Paul Nagle, who's going to, with his extensive background in this field, and he will make a short comment and then lead off the questioning.
Let me also say thank you for that great presentation. Certainly seems whether you follow the data or follow the money, a lot of those paths lead into the cloud. And you certainly see companies, big and small, whether it's Tom's e-commerce surf shop or much bigger companies, pegging their future growth on the cloud. and maybe even some attorneys too. From where I sit on this side of the Atlantic, I'm very focused on public policy. So maybe a more macro level than someone inside a legal department or in a private practice. And I think there's a few areas germane to this discussion, that I certainly try and watch and just wanted to share some thoughts there with you guys. Standards development is one. It's, I think, important for a couple of reasons. One, just as you sometimes have different legal regimes developing right now, you have different standards development, sometimes regionally. And standards development becomes important because it helps set the baseline of responsibility for the various players and at the various stages of the cloud ecosystem. I also personally try and follow it a little bit because I think it's a great way to understand the technology, which, as was mentioned, is so important. Because one way or the other, if you don't understand the technology, whether you're trying to influence a policymaker or advise your client, it's going to be really tough to do if you can't overlay both the legal pieces, whether it's contract law or what have you, with how that technology interacts with it. And then I think another very interesting area where on this side of the Atlantic, perhaps a little bit behind the EU right now, is antitrust. And you're seeing an increasing focus on how to apply antitrust law to some of the larger technology companies. And that impacts cloud in a couple of ways. One is there could be structural changes to a lot of the big cloud providers, and that may have some impact. And then there's also the effort within this part of antitrust law to define what is the market for data. What is data's value? Does that change on how you use it? When can data collected in one instance be used in another? And that very much can impact cloud providers and ultimately cloud policy. I, as a consumer, like that, a certain amount of my data is collected and easily accessible. Because it can bring great value to me. I very much like being able to find the same set of plates that match my current ones after my 5-year-old, or more likely me, break too many of them, right? And I don't want to, worry about matching them up. I just want to be able to go online and get the same plates over again. At the same time, you have to figure out, well, how do you protect consumers from harmful uses of data, right? I don't want, maybe if we're not talking about plates, but we're talking about, bottles of bourbon, maybe I don't want that information out there so much. So you have to understand then, how does the data piece, some of the cybersecurity pieces that go with that, fit into the overall cloud picture. And in the US, at least, right, we don't have a GDPR yet, so we don't have a single federal law that covers all privacy issues. We have some federal standards that relate to particular areas of privacy law, perhaps health information or information relative to minors below a certain age. But we also have the states being active, right? And so you have California doing things. And it may be that antitrust law ultimately ends up setting some of the more federal looking privacy practices and standards in the US. So you sort of have to be able to follow all those pieces and kind of overlay them together. And that's one of the areas I really like about it. But it can make it frustrating too, because you don't have a single answer and it can change. And so you try and follow that data and figure out which laws and which standards apply at any given time. And then relate that back to how do we protect the consumer? Or at least, in my job, we do that because you want to look at that lens of how do we give value to the consumer, but also protect them from harmful uses. And how do you balance that against innovation? And what can technology do to protect the consumer versus what do regulators have to do? And obviously, that answer doesn't always come out the same so far. And industry, sometimes industry has a role to play. Industry can also like regulation, right? There's a certain certainty that comes with some regulation that industry can sometimes like. But we're certainly seeing that play out. And maybe I'll use that to transition to this Q&A portion of today's webinar and just ask that, as we see these different approaches, EU acted sort of among the first in putting GDPR out there. Do you consider the EU's approach to data protection to be too restrictive as it relates to cloud services?
Paul, thank you for this question. Our answer is not obvious. As a consumer, as a Wojciech Jarosinski, I'm really happy with what EU is doing. But this audience deserves a better answer than that. And from the looking at the bigger picture, getting back to the example of Tom that I used before, if Tom is approached by European customer, as we look at the GDPR, he has to use GDPR, he has to apply GDPR. Of course, there will be no way to enforce GDPR over him, but basically he needs to take that into consideration. And perhaps that's even affecting American business to some extent. If Tom wanted to outsource his services to European Union and buy servers within European Union, the provider of services would need to question himself whether he can actually, after Schrems, to transfer the data back to Tom from our example, even though this is just American customers' data. Let's assume for this example, and that puts a huge burden on business operations of day-to-day management of IT companies in Europe. That basically makes them less competitive in the world. And that's the simple layer of just costs of running a business. And there is also the bigger picture of development. Our approach to data protection, for instance, prevents good growth of AI. We cannot feed AI with big data chunks in European Union because we don't have big data chunks due to regulation. So the question is whether we will not stay behind of the development, for instance, AI and modern worlds. Personally, I'm a huge fan of free data, and I think Europe went a little bit too far.
Great question, Paul. Good way to lead off. So I definitely encourage people in the group to start typing your questions in the chat. I'll ask a question to both of you, which you've both started to address. But as you look into your crystal balls and you think about, what are the biggest policy and legal challenges that you see on the horizon? Paul referred to antitrust, and maybe he might elaborate a little bit about that for the people who don't read the US newspapers every day, about what the Congress has been lumbering around about antitrust. And also from, of course, Wojciech, you've talked already about data privacy and how hugely central that's been in terms of concerns and development of cloud technology and use of cloud technology. So let me go back to you, that in addition to the thing you've already mentioned, what do you see as the biggest legal and policy and maybe political issues related to cloud technology that are likely to be on the horizon in the US and in Europe? Let me start with Paul, since we already were talking about the antitrust, and then I'll come back to Wojciech.
Sure, thank you. I guess just quickly to expand on the antitrust piece. So in the US, it's been announced that the Department of Justice is looking at Google, Alphabet for across antitrust concerns. The FTC has made indication that it's also looking at some of the larger tech companies. Congress has been involved, but I don't think anybody knows exactly where they're going yet with this, right? Because it is all still very new, and trying to understand the uses of data and what the marketplace might be from service to service is a very complex issue. I'm not, antitrust specialist, but I know enough to know that antitrust is very data driven, and antitrust cases take years to evolve. So even over the course of a case, things can change and grow or can evolve, significantly changing the facts on the ground. But I think over the next couple of years, there is enough, I guess, support for addressing some of the issues that antitrust law presents from both Republicans and Democrats. I would expect to see something on the public policy case without speaking to the merits of an actual antitrust law case. But I think you could see something in the public policy space. But again, I think they're gonna have trouble, finalizing what the details are. And part of that and I think we've touched on it, but maybe to just say it out loud again, one of the big issues is certainly just the cross-jurisdictional nature of these services. And so you also, if you're a public policymaker, you're worried about the service itself, but then you're also perhaps looking at the broader geopolitical impact. And what do these companies, you're looking at your domestic marketplace, but you also need to look at an international marketplace, and how does that inform what you may or may not want to do on a policy side. So I think that's going to be a real implication, for the cloud and for anything that obviously touches the digital commerce space. And how does, the internet had traditionally been fairly free of borders, and you're starting to see some balkanization start to happen, whether it's because of privacy law or national security laws or something else. And it'll be interesting to see how that plays out and impacts cloud legal issues.
Great, thanks. Wojciech?
Thank you. That's a difficult question, but honestly difficult, because a year ago, I would probably have totally different answer than today. During 1 year time of the pandemic, I've seen clients, a totally traditional institutions in Poland, the administrative institutions of the Polish government that were planning to migrate to cloud in 10 years time, switching to cloud over a weekend. And that really happened. I mean, we migrated to cloud in such a rapid fashion during the pandemic to enable people to work. Sometimes, basically, institutions were facing multiple devs within their ranks, and they had to migrate to the cloud to ensure continuity. And what will be the future after such a rapid growth is so difficult to say. But if I were to focus my attention on anything, that would be American-European relations. Right now, in the European Union, the advisory body is working on how to deal with post-Schrems 2 fallout, and how to enable transfer of data to the United States. I mean, any distraction in the legal system cost for good reasons, I believe Mr. Schrems has, good motivations, probably creates a good value. And that discussion, those thoughts that are shared, that probably we should look more into technology measures that are supposed to protect data on American servers, not just organizational. That may be a good thing. And if I were to focus on developments, it would be how the data commerce, to link these two words, regulated between America and the European Union. And I believe it has to be regulated.
Thanks. I have a question from Professor Duggan. And as many of you know, we have at Catholic University a center on compliance, internal investigations, and corporate responsibility, which Professor Duggan heads, and did a webinar on this in October. So her question, not surprisingly, overlaps in that area. These differences in approach to data privacy have all sorts of implications for corporate compliance functions and internal investigations. Is there hope of finding ways to harmonize approaches for a global company's own internal operations when they involve cross-border investigations? I'll turn to Wojciech, who's a major part of his law practice is dispute resolution.
It's a difficult, the questions just get difficult, more and more difficult. Yeah, one of the concerns that we in Europe have is that actually in states, the investigation rights and the depth of the investigation is basically too broad. And that's why the obiter dicta of Schrems 2, the court said that, not really, the American regulations are too far-reaching and you should not be transferring data there. And so whether it's possible to harmonize that law, I think is more a political question than a legal question. Lawyers will certainly find a way, but I'm not sure if there is political willingness to harmonize the law. Perhaps there is a value in being able to have those systems different and enable businesses to work in a way that is convenient to them in a jurisdiction where they originated and not being subject to laws of another country. That when it comes to investigations, however, I strongly believe that litigation, like traditional litigation related to contract, tort law, etc., it will allow for certain degree of data discovery or data requests from other countries. It's basically in the interest of the parties who are a part of the conflict of the dispute resolution to produce the data to support their arguments. And maybe that will be the solution within the private law. The criminal law seems to be a challenge.
And I'll mention again that our whole webinar next week with Justina Regan and Doug Bonner is about data privacy, focused in part on the United States, where again, as I think both of you have alluded to, you have the additional cross-border complexity of having states stepped in. And so the problem with people having various states, and I think one of their central focus is going to be the initiatives to try to harmonize within the United States. So there was at least one federal approach. Paul, is there anything you wanted to comment on this? Or
No, it is a very tough issue. Hope springs eternal, so I do think someday there will be some harmonization, but that someday I think is still a good bit off on the horizon. There's just not enough common understanding, I think, and even enough of a common vocabulary to get there just yet. Because already, you know, you think about what started the Schrems case and you know, where the services existed then versus where they are now, and how much more data keeps going out there, what the relative value of that data is, depending on what country or jurisdiction or market you're looking at. And I think it's just going to take a while to sort it all out. And you know, it really disadvantages some of your smaller or medium-sized players, because it's that much harder for them to deal with, as opposed to the larger global corporations, who it's not any necessarily easier to deal with, but they have the resources to which they can work their way through.
thank you. We have about 7 more minutes on the recorded part, and then we'll have another half hour after that. We have some good questions here. I think we're probably going to have time for maybe a couple questions before we cease the recording, but then we're going to go on, you know, and then have another half hour when we can probably reach everyone's questions. So this is a question from Marcin Klesiak. When data is stored in the cloud, the actual bytes must probably physically be stored somewhere. Does the place of their storage have any legal significance? I'm going to turn to Wojciech.
Thank you. Of course, it does, but I will start with the beginning of that question, which is an interesting part of cloud computing. When data is stored in the cloud, the actual bytes must be probably physically stored somewhere. Yes, that's true, but just half true. Because of course, there must be located on some server, but then would that single byte, is it possible to recreate the data from that single byte? I'm not sure, because actually the architecture of the infrastructure can result in division of that data between multiple locations where the servers are stored, and only upon user's request or the specific user request that has access to the data, the information would be recreated from the data. But having said that, yes, location of the servers is important, and from the perspective of GDPR, that's basically European Union or European Economic Area.
Thanks. We have a question from Katarzyna Wisniewska. to Wojciech. I would like to ask whether there is any, and if yes, then what is the legal regime applicable to cloud computing based on Polish contract law? Can it be described in terms of an existing contract type, or is it a new type of contract?
That's an interesting question. I guess I'm actually finishing litigation related to that concept. As I said, the Julius Caesar institutions of Roman law can be somehow forced to new business ventures, but at the beginning of inception, there is always a doubt. And right now I'm finishing litigation related to cloud software, which was provided by American company to another American company, actually. However, the arbitration is taking place in Poland because the investors in one of the companies were Polish. And one of the American companies is claiming that the usage of that software that was performed through the cloud was actually using within the framework of the license agreement, not software, not service agreement. So we do have standards, we do have like framework of law that applies to cloud. My strong belief is that this is simply service contracts that are applicable in these situations, but the inception is slow and sometimes takes time for lawyers to understand.
Okay, this was a perfect transition to what will be our final question on the recorded part it's a question from Justina Regan. Could you please elaborate on any conflict of laws concerns with respect to cloud computing agreements? Which seems is what we were just talking about. So I'll direct that to both of you, and then we'll switch off the recording and continue to the rest of the questions we already have. So Wojciech, then Paul.
Sure. With traditional contracts, it's easy to identify where performance is where the actual performance is taking place when the goods are delivered or the service is provided from one party to the other. It's easy to locate the point of origin and point of delivery, or the point where structure is created. In the cloud, it's totally difficult. So we have those data centers where the actions are actually performed within these systems or on the data that are in one location. We would have the purchasing authority in another location or the purchasing entity, and the user of that service or the vendor in another location. And if they live in different jurisdictions, the possibility for forum shopping is so easy and so open. Basically, distils to the fact who will convince the court to hear the case first and enforce their jurisdiction. So having settled jurisdictional matters within the contract basically helps to manage the contracts. That's my perspective. I wonder if Paul, you have a different approach to that matter.
No, I think that's right. Because you can interpret it so many ways, and I think what will help to some degree is as some of these cases proceed, I do think you'll see some changes in the way people architect their systems, right? Because traditionally it was architected, to the point, if I wanted to save money, maybe I would want to set up my server somewhere else, and the data could even be at rest there, but I might still be able to peer into it and see it. And I think you're going to see people being forced to architect their systems in a different way to make that not be possible. And that may be the way some of these jurisdictional issues, unfortunately, have to get solved. But with that comes certain costs to the economies of scale and the efficiencies that we already talked about, which are so far been benefits to driving these new services and driving this additional value add to consumers. So it's going to take a little while to play out. I don't know that you're going to see a whole lot of new legal principles developed or other than traditional contract remedies, but I do think you'll see technology respond as those traditional legal principles of dispute resolution, conflicting laws get applied, and then people will change their architecture to push the outcome in a way that's advantageous to them.
Thank you so much. So we are going to turn off the recording at the 60-minute mark, but then we're going to move right on for questions in the chat. If any of you have to